All right, let's jump right in. If your organization is touching anything related to emotion recognition AI, you need to listen up. The new EU AI Act, it's basically turned the whole field into a compliance minefield. So, in this explainer, we're going to break down those critical risks and really get into why this tech is suddenly under such a powerful regulatory microscope. And look, this isn't just me speculating. The Dutch Data Protection Authority, the AP, one of the big players in the EU, just dropped a bombshell report. The verdict they delivered? Absolutely devastating for this tech. This quote right here, it perfectly sets the stage for the high-stakes battle that's already underway. Okay, so here's how we're going to tackle this. First, we'll look at that regulator's verdict. Then we'll dig into why the science behind all this is so shaky. From there, we'll break down the AI Act's new rules, look at some real-world risks, and wrap it all up with a compliance checklist you can actually use. All right, first up, the verdict. A really key EU regulator has basically drawn a line in the sand when it comes to emotion AI. You know, this report from the Dutch DPA is a huge warning shot for anyone getting ready for the AI Act. This is not some stuffy academic paper. It's a direct, no-nonsense takedown that connects the dots between the flaws in the technology and the very real dangers of discrimination and privacy violations, which, by the way, are exactly what the new law is trying to stop. So, why such a harsh verdict? Well, it all boils down to one thing. The science it's built on is, well, it's incredibly shaky. See, the whole house of cards is built on two, frankly, flawed assumptions. First, this idea of universality, the notion that we all show our emotions in the exact same way. It just completely ignores cultural differences, individual personality, and, context. Then there's the second problem, what the AP calls problematic proxy coupling. It sounds complicated, but it's simple. The AI isn't really measuring your emotions. It's measuring physical signals, like your heart rate, and just guessing that it's an emotion. And that link, it's just not reliable. And this quote from the AP's chairman just nails it, right? A high heart rate doesn't automatically mean fear. Maybe you just ran for the bus. A loud voice isn't always anger. It could be excitement. The system is just making a guess, and let's be honest, the stakes are way too high for guesswork. And this is where it gets really serious. This shoddy science leads directly to a massive risk of discrimination. The AP pointed to studies showing that because these systems are often trained on biased Western-centric data, they're much more likely to assign negative emotions to people with darker skin. That is a textbook example of a biased outcome, and it's a giant flashing red light under the AI Act. Okay, so we've seen the scientific problems. Now let's look at how the law deals with them. The EU AI Act essentially builds a regulatory cage around emotion AI, specifically designed to contain these exact risks. The Act handles this in three key ways. First, some uses are flat-out banned. We're talking about workplaces and schools where there's a clear power imbalance and real consent is basically impossible. Second, for pretty much every other context, it's automatically slapped with a high-risk label. And trust me, that brings a mountain of compliance work with it. And third, you can't forget the GDPR connection. You're processing biometric data, which is special category data, meaning you need an absolutely rock-solid legal basis to even think about. So enough with the legal theory. Let's talk about what this looks like in the real world. The AP actually investigated some common use cases, and what they found is a major wake-up call for any compliance team. Think about wearables, for instance. Your watch gives you a stress score. Okay, but how? What's the algorithm doing? More often than not, it's a total black box. This is a direct violation of the AI Act's new transparency requirements and the right to an explanation. You can't just present a subjective guess as a hard fact. That's a massive compliance fail. And here's a really sneaky one, General Purpose AI, or GPA. Think of a big language model. It's not marketed as an emotion detector, but it might have that capability baked right in from all the data it was trained on. So if your company plugs that model into one of your systems, you could be accidentally inheriting a non-compliant feature, and you wouldn't even know it. Oh, and the classic customer service example. How many times have you heard the justification that they're tracking emotions for training purposes? Well, the AP came down hard on this. They're saying that excuse just doesn't cut it. It's too vague. It fails the GDPR's tests for transparency, for purpose limitation, and for getting valid consent. It's just not good enough. The AP actually used a brilliant analogy for this. They said, think of the AI Act as the safety regulations for fireworks. The law makes sure the firework is built safely so it won't just explode in your hand. But It's still up to your organization to decide if it's a good idea to set that firework off inside a crowded hospital. The point is, just being technically compliant isn't the whole story. You have to think about whether it's responsible to use it at all. Okay, so that brings us to the most important part. What do you actually do about all this? Let's get into your action plan. This table lays out the key areas you need to focus on. First, classification. This one is high impact. You absolutely have to know if your specific use case is prohibited or if it falls into that high-risk category. Next, transparency. Also high impact. You have to be crystal clear about how your system works and what its risks are. Then we have impact assessments. You'll need things like a DPIA and a fundamental rights impact assessment, and they have to tackle the discrimination risks we talked about head-on. And finally, suppliers. You've got to put them through their paces and set really strict requirements for their training data and how they validate their models. So, to really boil it down, here are the 5 big recommendations coming straight from the Dutch regulator. Number 1, be extremely cautious. Always look for less intrusive options first. 2, know your classification. The safe bet? If it's not explicitly banned, you should assume it's high risk. 3, ensure real transparency. Vague legal boilerplate isn't going to fly anymore. 4, your impact assessments have to get real about the scientific weaknesses. Don't gloss over them. And 5, scrutinize your suppliers. Demand proof of data quality, validation, and how they're tackling bias. Look, the message here couldn't be any clearer. The party's over. That whole era of just playing around with opaque, unproven emotion recognition AI, it's done. The Dutch DPA drew a line in the sand, and the EU AI Act has now carved that line into stone. So this leaves every organization with a pretty stark question to answer. Is the AI you're using actually compliant with these incredibly strict new rules, or is it a massive liability just ticking away, waiting to explode? The time to figure that out isn't tomorrow, it's right now.